The Family Code of the Philippines, Executive Order Number 209, signed into law by President Corazon C. Aquino on July 6, 1987, and which became effective on August 3, 1988. Chapter 1, Requisites of Marriage. Article 1. Marriage is a special contract of permanent union between a man and a woman, entered into in accordance with the law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. Article 2. No marriage shall be valid unless these essential requisites are present. Number 1. Legal capacity of the contracting parties, who must be a male and a female. And number 2. Consent freely given in the presence of the solemnizing officer. Article 3. The formal requisites of a marriage are: Number 1. Authority of the solemnizing officer. Number 2. A valid marriage license except in the cases provided for in Chapter 2 of this title. And number 3. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Article 4. The absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35, Paragraph 2. A defect in any of the essential requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable. Article 5. Any male or female of the age of 18 years or upwards, not under any of the impediments mentioned in Articles 37 and 38, may contract marriage. Article 6. No prescribed form or religious rite for the solemnization of the marriage is required. It shall be necessary, however, for the contracting parties to appear personally before the solemnizing officer and declare in the presence of not less than 2 witnesses of legal age that they take each other as husband and wife. This declaration shall be contained in the marriage certificate, which shall be signed by the contracting parties and their witnesses and attested by the solemnizing officer. In case of a marriage in articulo mortis, when the party at the point of death is unable to sign the marriage certificate, it shall be sufficient for one of the witnesses to the marriage to write the name of said party, which fact shall be attested by the solemnizing officer.